Good afternoon, everyone. My name is Guillermo Patino. I am the chairperson designee for the New York City Loft Board. I would like to welcome you to our December 8th, 2022 public hearing on the proposed amendments to the Loft Board rules, which consist of two chapters. The proposed rules we are hearing today amend Chapter 1 and parts of Chapter 2. This hearing is also being streamed online. In June 2019, the New York State Legislature amended the loft law to include, among other changes, a new window period for coverage and modifications to the eligibility criteria for coverage. The proposed rules incorporate the 2019 amendments to the loft law and streamline other procedures. Specifically, the proposed rules repeal Chapter 1 and reenact a new Chapter 1. The current Chapter 1 includes the board's procedural rules. Included in the proposed changes to Chapter 1 is a new definition section, new requirements that allow for the electronic filing of certain documents in most cases, and amendments to the service requirements. In Chapter 2, the proposed rules add the compliance deadlines for the 2015 and 2019 amendments to the loft law, amend the occupant review process to provide transparency by requiring the sharing of plan examination objection sheets, and allow for the electronic filing of legalization plans. The changes also propose a sliding scale for the time allowed to file an alternate plan or comments. Also notable are the proposed changes to the Loft Board's fine schedule, which increased the maximum penalties to $25,000 pursuant to 2019 amendments. These proposed rules also create new penalties for violating a Loft Board order and for filing a false statement. In accordance with the New York City Administrative Procedures Act, the text of these proposed rule changes were submitted to the New York City Law Department for review and circulated to other city agencies that may be affected by these proposed changes. The text of the proposed amendments and notice of this public hearing were published in the city record on November 3rd, 2022. A link to the text of the proposed changes was also posted on the Loft Board's website and the New York City Rules website. Anyone intending to present oral comments today must do so in accordance with the following rules. Each speaker must sign in with the Secretary of the Board. A number will be provided when you sign in. Each speaker will be called to the podium in the order of the sign-in sheet. Please pay attention to the number you have been provided. These numbers will be called two at a time. If there is no response, the Secretary will go on to the next number. To ensure that everyone who wishes to speak is provided an opportunity to do so, each speaker will be limited to a maximum of 3 minutes to testify. Finally, written comments regarding these proposed rule changes may be submitted to the Secretary of the Board today, emailed to New York City Loft Board at buildings.nyc.gov, or mailed to the New York City Loft Board at 280 Broadway in the atrium. All written comments submitted by December 15, 2022, together with a memo summarizing the oral public comments received at today's hearing, will be on file at the Loft Board's office and available for public review. And finally, I'd like to thank the Loft Board staff and the board members and the members of the public who worked on these rules for quite a few years. So congratulations, very excited to be here today at this hearing. And with that, I'll turn it over to Ms. Rivera to call up our speakers.
Great, can you hear me now? Awesome. Good afternoon. Thank you, board. Thank you, chairperson, and more importantly, thank you for the residents for being here and allowing me to have the opportunity to testify today. My name is Christopher Marte. I'm the city council member for District 1 in Lower Manhattan, the home of many of IMD and Loft residents who will be affected by these rule changes. Streamlining and simplifying the rules and procedures of the Loft Board are goals that are timely and can benefit Loft residents and owners alike. Allowing more electronic documented filings and distribution will make processes more transparent and accessible, and strengthening the occupant review of narrative statements and legalization plans by owners will give residents more voice and power in the face of potential illegal work and practices that we have experienced in the past. Further strengthening basic livability requirements and ensuring that loft tenants know and understand their status and protection are common sense proposals. I already witnessed in my short time in office how loft tenants have been gaslight and manipulated by confusing and often absent information about their rights, with enforcement falling into gray areas between the Loft Board and Department of Buildings that could leave many tenants unprotected against harassment and other blatantly illegal action by owners. Importantly, IMD units have been sitting. Importantly, many IMD units have been sitting in limbo for decades, and I hope that these changes will help achieve full legalization and the clarity and comfort that comes with it. I'm happy to see this opportunity for testimony and encourage the voices and opinions of those who made it here today are strongly considering the finalizing of these amendments. While loft law can be intricate and sometimes hidden, I'm amazed by the expertise held by many of the loft tenants themselves. I see many from my community here today, and I urge this board to listen to them very clearly and use their recommendations in action. Thank you.
Hey, y'all, how exciting. It's my first time to be at a live meeting since I can't remember. Thank you. And thank you all for those of you who are wearing masks. This isn't over yet. My name is Tom Kaler. I live at 525 West 45th Street in Hell's Kitchen. I've been living there since 1977. Now, to my mind, there are two aspects to the rules which you guys are going to consider adopting here. There's the rules themselves. There's the policy, the law. And then there's how are the rules applied, which we call the practice. Now, the question is, does the practice always follow the law, or is it more or less a shrug? Now, for instance, in our building, during the narrative statement process, the landlord filed a false PW1, claiming that no tenants lived in the building. When we brought this to the attention of DOB, we were told, well, even though the law rules that it is illegal to knowingly or negligently submit any document to the department that contains a materially false statement, well, in this case, a deputy commissioner for legal and regulatory affairs said the department can't conclude that there was an intentional false filing. So there's the law, knowingly and negligently, and then there's the practice. Well, was it an intentional false filing? The policy and the shrug. Then the landlord filed a false ZD1, falsifying the height of the building so that they could circumvent the special Clinton district rules for mid-block bulk. We brought this to the DOB and we're told, hey, well, nobody until the tenants actually measured the height of the building. So, hey, how tall is it? Who knows? The policy and the shrug. In May of 2022, the landlords now filed a document with DOB saying, hey, we don't have to do the street tree requirement because all we're doing is legalizing the existent lofts in the building. Well, this is false. They added 10 free market units in what previously had been commercial space. But hey, listen, I don't fault landlords for filing false documents. Why shouldn't they? What is the consequence for filing a false document?
30 seconds.
The shrug. So as you consider these new rules, please consider that there are the rules, and then, hey, there's the shrug. Thank you.
Unlike Tom, I need the microphone. My name is Brett Hiker. I live at 239 Banker Street. Thanks for the opportunity to talk. I'll keep this short. My situation is I have a 3-bedroom apartment, and in order to bring the building up to code, they want to take my 3-bedroom and turn it into a 1-bedroom, but they've made it very clear they don't have to change the rent at all. And it's just like a loophole for them to, get people out of a rent stabilized situation. And I have a friend who is a contractor who said, he's like, hey, I can build you fake bookshelves so you can have like fake rooms and keep roommates. But like, I don't know if you guys are history buffs, but when we're at the point of building fake bookcases to hide people, like there's something wrong with the system. And so, I mean, I think you guys have the power to fix that. So that's it. I feel like our landlords are millionaires already. They don't need more help. Thanks, guys.
Hi, my name is Cynthia Chapin, and I have lived at 482 Broadway in apartment 5N since November 1st, 1979. I just wanted to stress the importance of the Loft Board's oversight of the legalization work and ensuring that the work is done in accordance with the plans before the Loft Board signs off on anything. That's all I have to say.
Hello, my name is Aaron Scaturo. I'm a tenant at 79 Lorimer Street. My loft law situation began in 2014. The DOB shut my building down and I was forced out of my home with no notice. I'm a woodworker and a carpenter. My landlords locked me out of my home and my shop for 4 years before I had access to my tools. It had an impact on my career. In this time, I was essentially homeless, forced to choose between my career or a home, not knowing when the vacate would be lifted. At one point, I was sleeping in a 24-hour fitness parking lot in my van, so I could rent a shop and not destroy my career further. I was allowed 2 days of access for 1 hour each in this time before I was awarded my loft law coverage. In this time, my landlords made it, I can't blame them, but the elevator was not working during these times, so I was forced to leave my tools up there. Finally, I was awarded my coverage and I moved back in. They destroyed my home. They destroyed my shower. I went through this global pandemic that we're still in without a shower or a kitchen. My landlords have ignored all of their responsibilities to the point where I felt like I was grinding my life down to nothing. I'm standing before you today to tell you there are laws, but if someone has enough money, they can ignore them. And it ruins lives. And I choose to continue in this battle because if I don't, bad people win. And that's all I have to say.
Hi. To some of you, I might have been a mysterious presence in the room for the last 6 years, often in this room during the process. And the tenor of my comments today are a little different than the others. My statement is that the loft law has become an impediment to the process that it was intended to facilitate. It's not a statement I'm happy to make, but it's disappointing that these rules didn't do what they were intended to. They're not going to streamline, and they're not going to really help New York City do what New York State thought it could do within 36 months. So I pose a big what if. I mean, what if there were only 36 months left for the Loft Board to get all of the buildings in its jurisdiction to the finish line? Would this draft look the way it does? I don't think so. I think it's a missed opportunity. I sat here kind of like a crazy person for 6 years and 5 different executive directors, and so much work went into this, and I want to thank you guys for doing that. I just want to share what I think happens. And February of 2021, Mr. Clark of the Loft Board said, in trying to defend why there was some changes made to extension applications, but he said things get stuck. And I think we can all agree they do. Things get stuck and they are stuck. And that's really not the intent, and it's
60
dangerous.
seconds.
So I don't know if you guys are aware, but in 2019, the legislature not only expanded the loft law against the wishes of the New York Fire Department lobby, but they also held a 6-month study on code enforcement. And this article is titled Scoofus, I don't know how to say his name, issues final code enforcement report noting systemic failures at all
seconds.
levels of government. And so I thought it was kind of interesting because it's a systemic failure. It's not any one party, one person, but he says code enforcement is an issue that touches every single person in our state. It's not overly dire to say that more first responders and more residents will perish from dangerous conditions if code enforcement is not better prioritized in New York. I'm hopeful this report
Thank you.
will
Your
shine
time
a
is up.
light on state and municipal shortcomings. And I'm here as somebody who has lived in lofts for over 30 years in Williamsburg. And this is an article from the year 2000 from the Daily News when it had an exclusive. And it's the trendy lofts that in Brooklyn. And none of
time's
them
up.
have been escorted by the loft board into code compliance yet. And I want the board to explore why and create a boat that will float. I think I'm a native New Yorker, and I think New York deserves a boat that will float.
Okay, thank you.
Is that? Thank you.
Hi, my name is Christina Crapanzano. I live at 239 Banker Street in Greenpoint, Brooklyn, and I want to begin like my fellow tenants. The loft tenants have said, and just thank you for your efforts to improve loft law, and also thank you for providing this forum for us to discuss our experiences with you. I am a writer, and I typically avoid public speaking as much as possible, so I hope that at least underscores how much this matters to me and why I'm here today. Like I said, I share experiences with other loft tenants battling misinformation, unannounced construction, mold, heating issues, lack of insulation, etc. But I want to use my time to specifically speak about an issue facing my unit on the first floor of 239 Banker. When I moved into Baker Street more than 5 years ago, my roommates and I signed a lease for a 3-bedroom. We even went through an application process providing cash for a background check and also social security numbers. It was an existing 3-bedroom, and we signed a lease because as 3 people in a 3-bedroom. Our building was purchased in 2019, and throughout our narrative statement process and other negotiations, conversations, and accruing substantial fees spent for legal and architectural counsel, we found out that there's absolutely no way to legalize my apartment and keep the existing bedrooms. Rather, we're going from a 3-bedroom to no bedrooms. We're going to a studio due to light and air limitations. There are 2 of us who are living there right now who are both protected occupants. However, we've been told that the loft law has no provisions for this sort of situation. We are not only in a situation where we need to fairly decide who gets to stay, but we are also in the position of asking, can either of us afford to stay? Compounding the issue of affordability, in 2018, our previous landlords, without any notice or explanation, switched our gas stoves and heaters to electric. It was around this time that I actually learned that the loft board existed, because we had to call 311 due to several instances of workers entering our apartment without so much as knocking, using the master key from the landlord. Because of the switch to electric, combined with the lack of proper installation, our Con Ed bills have increased by more than $300 a month, and it's
60
still
seconds.
cold in our apartment. Some of my fellow Banker Street tenants have also had electric bills that exceed $700 for one person. I understand why they changed from gas to electric. It's a safety issue, but there's been no effort to offset the significant added costs. In fact, they've raised our rent later that year. Going from a 3-bedroom to no bedroom takes away our ability to split the cost of the unit. This, combined with utility costs, has also made staying in my home unsustainable. Our lawyers have tried to discuss the possibility of rent reduction with our landlords. However, after repeated attempts, we've been told that they will not budge, and
30
we're at
seconds.
an impasse. As we've been told by council, there are no provisions in the loft law to help us. Our only option is to ask you to reconsider the loft law to prevent tenants like us from losing our homes. Thank you for your time and consideration.
Okay, my name is Marguerite Chandler, and my status is loft tenant. I want to thank the loft board and Mayor Adams for the opportunity to enjoy affordable housing in New York City. It's made a massive difference in my life and in the life of my son, who is an adult disabled. Let me bring to mind, to the mind of the new members of the Loft Board, and those who have been around longer, the name Vito Lopez, who is now gone, but who successfully advocated for this loft law after many years of failed attempts. He made a great difference in my life and in the life of many others. I will never forget. May he be resting in great peace. I want to always remember the people who have made a difference in my life. Okay, to each of you personally, you really matter to me, and I'm very grateful for the work that you're doing. First part is thanks. Second part is pleading my case and the cases of many others like myself. I want to remember those who are on the street or who have had the misfortune fall upon them of being displaced from their shelter. I wish for the continued work of the New York City administration government toward affordable housing. And I wish this will limit the numbers of tragedies that occur as a result of misplaced persons. Okay, my story. 7 tenants. The renovation that's planned will only include 2 bedrooms. I have some concern as to the construction work. The owners of our building have neglected maintenance for 10 years. They allowed a biker club to live on the first floor, vacated space,
60 seconds.
for 2 years. And one of the bikers assaulted the tenant that they were living in the unit of I guess they wanted to scare her off because they wanted the space, all right? As a result, okay, in this, they were never fined, and the actual tenant has never been let back in, all right? So there's a selective enforcement of the vacate order, apparently. I realize the Loft Board needs to mediate between the rights of tenants and those of the owners, and I appreciate that. However, please understand how the past behavior of the owners of my building and the lack of fines and enforcement contribute to my feelings of unease and insecurity with the impending construction. If there was greater enforcement of the law and there was greater consequences for breaking it, I would feel less apprehensive toward the impending construction. This is in the context of no renovation nor normal maintenance for 10 years.
30 seconds.
Is it over? Am I done? Okay. Is that it? Okay, go on. Okay, if we take in housemates up to the number we had before to cover rent, we need to find housemates willing to sleep, I guess, in the general space. This was told to our group, or to me when I was there, by the previous Loft Board Chief Lanny. She said, you know, we could have that many people as we had before, but they just couldn't have bedrooms. All right, so whoever we take on has to be compatible with my son and myself. I'm willing to take on even presently homeless, but they must be solid people and without mental instability.
Time.
And I know that when
Thank you.
people are homeless, it can actually cause mental instability. So I would like some adjustments to be made regarding rent, considering the number of bedrooms has been reduced. Thank you.
Hi, my name is Paul Lieber. I live at 255 18th Street in Brooklyn. My wife and I are grateful to have loft law status, and as it's the only protection afforded to us as tenants. And we understand that the institution has its limits, but you, the Loft Board, are the only agents and intermediaries that can protect us. You are our only hope in most of these situations. As loft tenants, we do not have the same abilities to appeal for essential services, recourse, and remediation as anyone else does as a tenant in New York City under HPD. We cannot call 311, and only recently were we even granted the right to sue in housing court. Our building has been without heat since 2016. Ice covers our walls in the depths of winter, literally. Our electric usage increases by 300%, and we are still below legal temperatures. If the Loft Board enforced its rules, the landlords would owe somewhere between $300,000 and $1.5 million in fines for this infraction alone. This could act as a deterrent to their continued negligence and harassment. I ask you to please enforce it. Our landlord began facade work nearly 3 years ago, work in which we have no protection plan or agency in. We have endured 3 years of constant drilling, breaking through our walls, power washing into people's apartment, destroying property and the peace and the sanity of the tenants. December 23rd, 2021, they broke a 12-foot long hole in our wall with bricks falling into our apartment. We reported it. 7 more incidents occurred within 5 months. Same work, no repercussions. Another 12-foot long hole on the opposite end of our apartment filling with noxious
60
burning
seconds.
concrete dust. Concrete pouring in like a waterfall from 13 feet high down our walls, destroying our clothes where they sat. The first time it could be dismissed as negligent. Anytime after that, it is harassment. They were still drilling and scraping today. It is traumatic, supposing at any moment they can break through our wall again, and we have no recourse and no
30 seconds.
remediation and no control, besides appealing to the loft board. It is harassment, and we ask you to please enforce those rules. There is a new rule that requires architects attest in writing under penalty of fines, I assume, that the plans submitted are accurate and distributed to all parties. Please enforce that rule. Our narrative statement process began in 2014.
Your time's up. Thank you.
May I finish briefly? It is imperative that the loft board exercise its power in protecting tenants through increased enforcement of its rules. When they are not enforced, our trust in the institution wanes. These small examples are of a litany of wrongs that we endure, yet we continue to show up to defend our rights as tenants. We show up, we comply, we are exhausted and besieged as they chip away at the safety of our homes. We just simply ask you to please show up for us. We are in favor of these new rules, but please enforce them. Thank you very much.
Hi, my name is Julie. I'm a loft tenant in North Brooklyn. I've been in my apartment for 20 years. My husband and I have been in there for 20 years. I wanted to thank you for the opportunity to speak today. I've had very similar experiences, unfortunately, to the last tenant. My experience going through the loft law process has been exceptionally negative and exceptionally positive. First off, without the loft law and the loft board, I would not be able to afford to live in New York anymore. Without the loft law and the loft board, I would still be living in a dangerous, unhealthy building that was literally crumbling around me. It would take much longer than 3 minutes to go over all the traumas my husband and I endured, such as huge chunks falling from the ceiling on multiple occasions, nearly hitting me one time and my dog, dust and construction debris so thick in the hallway. My husband, who has asthma, had asthma attacks. I started getting asthma out of nowhere. We couldn't leave our building without physically walking through dust and debris for over a year. All of our exterior structural walls were literally torn down around us while we were living in the building. This is insane. They put a tarp up over scaffolding so nobody would see it. Inspectors never showed up to witness this for 3 years. Holes opened up and structural I-beams welded right in front of me, sparks and smoke everywhere. Landlord lied to my face that they were doing it. I'm a welder, I'm a sculptor. I know what welding is when I see it right in my face. We, of course, like many other tenants, didn't have heat for years. There's so much more, it would take me a long time. But the main reason I want to talk to you today is to consider new rules for safe, adequate, temporary housing when staying in the apartment or unit is just too unhealthy, dangerous, and disruptive. After a few years of intense construction, our landlord asked us to leave for 2 weeks. He told us to take a vacation. We cannot just afford to take vacations whenever we want. We left for 2 weeks. We came back, still no running water, no electric. We didn't have a bathroom.
60 seconds.
This work was not on our narrative statement. We literally didn't have a toilet, sink, or shower. He told us that we could stay in his apartment, an empty apartment, for 2 more weeks till it was complete. It took almost another 4 months. I lost my workspace, my internet access. The apartment he put us in had other tenants that had keys. One of them walked in on my husband taking a bath. It was infested with cockroaches, black mold everywhere. The ceiling was leaking everywhere. The floor had cracks to the
30
apartment
seconds.
below, which had tenants that were in a physically abusive relationship and smoked crystal meth that seeped up through the floorboards. I was getting physically ill. I had to leave and live with my parents for 2 months. My poor husband, who had a job in Manhattan, had to stay in this god-awful apartment. I'm just asking that you consider what will happen to tenants when work is done in units
Time,
where it is
thank
not
you.
suitable, sorry, I'm almost done, when it is not suitable to live there during the process. There needs to be specific laws so tenants and landlords know their rights and responsibilities. I had no idea what we could even do at this point. It was so exhausting and upsetting for us to go through all of this, but luckily it was just the 2 of us and my poor dog. I can't imagine how especially older tenants, tenants with children, and tenants with special needs could have gone through what we went through. Again, I want to thank you. Despite the constant exhausting harassment we endured from our landlord, our neighbor
thank
and
you.
us are very grateful for the loft law and the loft board that we can still live in our apartment, have affordable rent, but most importantly, live in a safer, healthier environment that is up to code. Thank you for your time.
Hi, my name is Felipe Ribeiro. I'm keeping track of my time, so if you don't mind. I'd like to thank you for allowing us to speak. The decisions that you make have tremendous impact on our lives, as you guys have heard. I live in 255 McKibben Street in Brooklyn. In the interest of time, my story picks up on the evening of Monday, January 29th, 2018. I came home from work at 7 p.m. to find a 50-page lawsuit duct taped to my front door with a notice to appear in 38 hours. The landlord's attorney had gone forum shopping and sued me in Brooklyn Supreme Court, alleging that I had derailed his attempt to legalize the building, therefore that I was a danger to my neighbors and he was entitled to a TRO, immediate possession of my apartment, and not less than $200,000 in damages. In the lead up to that lawsuit, I had foiled the loft board and discovered that the landlord's attorney had engineered the filing of no less than 25 sales of rights agreements with the compensation amounts either listed at $10 or redacted. 5 months later, the judge was not persuaded of our arguments that the building owners had obtained their permits using fraud and deception. Thankfully, I won on appeal to the loft board under Helene Balsam in late June of 2018. The reason I'm here today is to draw the loft board's attention to the 25 sales of rights agreements and that each and every one of them has a timestamp indicating the date and time they were accepted into the loft board's records. Each one of those contracts is fraudulent and was filed without the tenant being properly compensated. Every one of those agreements represents a tenant that was subsequently illegally evicted with a form letter from a law firm. If we calculate that each tenant could reasonably have negotiated their rights for $100,000, ballpark, that represents $2.5 million stolen from tenants and a pattern of fraud that does not require a law degree to detect, but that each bear the loft board's timestamp. It dawned on me that the lawyer who engineered the wording of these agreements did not learn how to do so from my landlord, that this is likely a template copied from other buildings and had been used against other tenants. So I looked up the lawyer's firm who represented my landlord, thinking there might be some way to infiltrate and find out what other buildings they
60
have
seconds.
represented before the loft board. But because these lawyers are not only not ashamed of their participation in this fraud, they advertise it on their own website. There are more than 40 buildings that the lawyer's firm has represented before the loft board in legalization issues, listed right on their website. I'm willing to wager that of those 40 plus buildings, a substantial number of tenants have been similarly defrauded. If the $2.5 million figure from one building is any indication, the loft board may have unwittingly legitimized a fraud against tenants ranging from tens to possibly up to $100 million.
30 seconds.
And that's just one law firm. I urge the loft board members to keep in mind the previous incarnations of the loft board's past unwillingness to enforce the law and apparent lack of basic common sense as the new rules are debated and landlords and their crooked attorneys attempt to portray themselves as the victims. Thank you again.
Good afternoon. My name is Jason Frosch, and I'm an attorney at Windles Marks Lane in Mittendorf. Many of you have seen my name on a lot of orders and proposed orders that have come before the Loft Board involving. Oh, sure, of course. Many of you have seen my name before on many cases before the Loft Board, but I want to come here and tell you that the Loft Board really doesn't see most of what takes up my day in representing responsible parties at the Loft Board, and that is legalization. And I want to point out that I think almost all, if not all, of the comments that we've heard today revolve around the legalization process and really not some of the other issues that the Loft Board tends to encounter most in their orders. The legalization process is completely broken. And I think you're hearing that from a perspective that comes from people that I don't normally represent, but I'm here to share the perspective of responsible parties who are doing their best to try to get through the legalization process that the Loft Board requires. It is not easy to take a manufacturing building and bring it into compliance with residential building codes in the city of New York. It is extremely difficult. It requires an enormous amount of resources. There are very few design professionals who are even willing to take on that onerous task. And it takes a lot of time and energy. Now, it doesn't go very smoothly. And the reason it doesn't go very smoothly is because the Loft law requires something that is extremely difficult to do. I'm not aware of a way to be able to do this job any more cleanly or simply or better for everyone involved than what is currently being done, because what is asked of owners and tenants under the Loft law legalization process is just incredibly challenging. So I want to state that perspective when I look at what's being proposed in these regulations regarding the legalization process. One, I think it's not enough.
60 seconds.
I respectfully ask the Loft Board to look at the legalization regulation, try to understand how the process works on a practical level, and see if there's a way to make this process better. Two, one of the biggest problems with the legalization process is getting through the narrative process, getting a certification. It creates enormous delays. It causes a lot of contentious feelings amongst the parties, and it's a little bit unclear, to say the least, exactly how that process is supposed to transpire. These regulations include additional delays in that process that only make it worse and more contentious. It adds additional time based on the sliding scale for the number of units in a building for tenants to file their own legalization plan, but does not provide owners with any additional resources in order to legalize a complicated building that's large and has many units. That has got to be addressed in these regulations in order to solve this problem and fix the legalization process. Thank you.
Hello, my name is Jens Rasmussen. I've been a loft tenant since 1996, 252 Green Street. Our building was purchased by a new owner in late 1999. And at that time, we had 3 covered tenants in the building. As soon as he got the first 2 tenants out, I'm the sole remaining tenant, he proceeded to gut renovate and bring them up to code. I am still have not entered the narrative process. I still have bricks falling out of my wall. I still have a leaky roof. And so I understand that there's a negotiation that happens during the narrative process, but this idea that that landlords can't afford, or it's impossible to bring a warehouse building up to residential code is patently ridiculous. Anything that these rules or future rules can do to increase and strengthen enforcement, I think are absolutely necessary, certainly for families like mine that are also living with Modine heaters still. It's just ridiculous that the enforcement is so pathetic, frankly. And I would love to see stronger enforcement. Thank you.
Hi, thank you for your time today, and thank you for your diligent work on these rules over the many years that it has taken. I would like to also speak to a common theme today, enforcement. The lack of enforcement in the building that I live in, 144 Spencer Street in Brooklyn, has led to decades of hundreds of tenants living below legal thresholds. We were registered in 2010 with the Loft Board. However, no IMDb number was ever posted. When speaking with our building management, we were told that our rent never increased because we paid on time and we took out all of our own maintenance work in our units, and that this was what it meant to have a good and friendly landlord. 10 years later, in 2019, we finally had our first narrative statement conference. However, our building architect did not come with surveyed plans and no engineering proposal to bring a 91-unit apartment building up to code. During the narrative statement conference, we spoke about many life safety issues at hand, including locked fire exit doors, mold, and illegal gas-fired modine heaters. The landlord insisted our heaters were legal, and we spent another year living without carbon monoxide detectors or any preventative measures to have legal heat. There's evidence as far back as 2000 that the DOB was aware of illegal gas work and illegal plumbing work. A violation cites that gas stoves are being hooked up in apartment 207, and there's a 3-piece plumbing fixture present also in
60
apartment
seconds.
207. The lack of coordination with the Department of Buildings by the Loft Board creates avenues for landlords to obfuscate the construction at hand. All loft buildings exist originally because they had illegal construction taking place. You cannot have a stove or a shower in a commercial unit. In many buildings such as mine, there were
30 seconds.
conversions to commercial spaces that were professionally certified by licensed architects and never inspected by the city. I would really encourage the Loft Board to work more closely with the Department of Buildings to inspect loft buildings, especially as they enter the IMD, to see if there are present life safety issues, knowing that it can take often a decade to have a first narrative conference to address these issues.
Your time is up. Thank you.
Thank you so much.
Hello, my name is Gregory Burgett. I live at 210 Cook Street in Brooklyn. I'm an IMD tenant. We just started our narrative conference process after getting loft law coverage in 2015, and I was somewhat surprised that, they did the survey of the building and then we received notification that there would be the first conference. I simply did not feel that we had enough time. It's kind of a visceral shock to discover that the conference is happening and then to consult with someone and they say, if you don't have a lawyer or an architect at this particular moment, you may never have an opportunity to have one represent you in the future. And we basically had 30 days notice to get together and represent our half, when I'm sure the Loft Board is sort of prodding and communicating with the landlord on the other side, and they know that the landlord knows that all this is going to happen and is coming, and the tenants just feel a little bit blindsided. So consequently, our representation is solely a function of who could take us on inside the 30 days for the first conference. And I think the entire thing has slowed the process down that takes years to unfold, clearly. But I think that process would actually go smoother and serve the tenant, everyone's interests more, if there was just some notice a couple months in advance that the tenants were, the conference doesn't feel real or like it's going to happen at all when you get coverage in 2015, and then in 2022 it's happening. It's just, we're surveying the building. Okay, well, it's been 7 years and nothing else has happened. So like, you just don't expect your initial narrative conference where you need representation to suddenly be 30 days away. So just some sort of notification that something is going to happen and you might need representation in the next 90, 120 days would have, I think, dramatically changed how we had proceeded. Mirroring things that other people have said here about trying to retain bedrooms.
60 seconds.
Given that the overall purpose of the loft law is to address the housing shortage. I think that's the like literal top line thing in the initial loft law. It says, due to the shortage of housing. It feels very strange to me to have these narrative conferences where the landlord proposes, we'll give you 0 bedrooms and 2 closets. And then I have an alternative proposal that says, we could definitely continue to have all of our bedrooms. And the party in the middle seems oddly neutral about this instead of just sort of, oh yeah, let's house one person in this or make it unaffordable instead of house as many people as who lived in it previously. It just seems peculiar and strange. It just seems contrary to the broader spirit of the loft law that the loft board wouldn't simply look at their proposal and say, why are you proposing to house fewer people in this unit than you could? That's my time.
Hello. I'm Alex Newstein. I've lived in Soho for 10 years as an IMD tenant. And my father, an artist, lived in Soho for over 40 years as an IMD tenant. We appreciate the unique privilege of being able to redress grievances with owners before the loft board. You are a uniquely specialized adjudicating body. My fellow speakers and I plead with you to double down on your mandate to help safeguard the rights and the practical remedies afforded by owners and tenants, but particularly the tenants whose resources are insignificant compared to the owners. For the second year in a row, we had no heat. It was 52 degrees indoors. Following a report to the city inspector, the owners finally replaced the radiator valves. Unfortunately, the new valves are flawed. Multiple times a day, water drips and splashes out of the radiator, sometimes with substantial force, soaking the floor and walls, risking mold and leaks to the apartments below. Only by following up repeatedly with the city inspector did the landlord replace the boiler. Finally, the owner cut off our access to the elevators. This caused great hardship to the tenants. 4 of the other IMD tenants are over 60 years old. 2 are in their 80s and have difficulty walking. The owners lied that the elevator is broken. It was not. They used it themselves frequently. This litigation before the loft board has been going on 3 years and has imposed crippling legal fees on all of us. It is telling that I'm reluctant to even bring up other issues because I don't want to overwhelm this body with a full extent of the problems. Ceiling leaks are normal. Our front door and buzzer have been broken for years. Our landlord owes over $22,000 to Con Ed, but refuses to pay, knowing that the only redress would be that we, the tenants, will lose our electricity. So we, the tenants, have been forced to pay Con Ed for the debts owed by the owners in order to keep the lights on.
60 seconds.
The conduct of our building's recent owners shows increasing disregard for their duties to the city and to us, the tenants, the laws that apply to them and that protect us. And they also disrespect the authority and the conviction of the loft board to enforce these rules. Owners frequently fail to respond to petitions, default on petitions, only to show up in the last minute, unprepared and uncaring. Loft board judges rarely, if ever, set an example by enforcing an owner default. I'm in favor of some judicial courtesy for occasional oversights, but this is systemic disregard of procedure. It is not only putting us in physical danger, it is an insult to your mandate, your authority, and to the principle of due process. So I want to ask the board for elaboration on the changes proposed today to the service requirements. The owners need reasonable regulation, and we need you to regulate them. Thank you.
Hello, thank you for taking the time to hear from loft tenants today. My name is Aruna Hikinian. I'm a tenant at 8-10 Grand Avenue in Brooklyn. I live there with my husband, 2 sons and a daughter. First, I want to start by thanking the loft board for making several important common sense improvements to the law. I remember going to see Ms. Shepard for a FOIL request for documents on our building, and I was shocked that so much relevant information relating to the sale of rights was blacked out. I was disappointed that this seemed to be overlooked, and there also seemed to be no possibility to correct this in place either. But today, I'm really grateful to see in section 20 of the proposed rules, it clearly addresses redaction, so thank you. I've been in our unit since 2005. We've seen the building ownership change hands several times. Each time, After about 2 years, the new owners, usually corporate structures, would get extensions without actually having to do any legalization work to make the building safer. Sadly, even with the new rules, the Loft Board has no real way of identifying the actual owners to determine if they're simply changing owners on paper to avoid compliance penalties. I would like to see the rules clearly address ownership changes by requiring transparency and full disclosure of all members of LLCs, especially if they're filing for extensions. Over 2 years ago, our gas was shut off because it was found to be installed illegally and deemed dangerous. The owners, instead of working to legalize the gas and make it safe, as it's an essential service they're required to maintain, they instead denied us gas for cooking and heating, gave us hot plates and space heaters. This was and still continues to be inadequate to cook and heat. Sadly, the Loft Board did nothing to enforce the warranty of habitability laws of the state of New York. And we're facing another cold winter. The owner then used the gas shutoff crisis as an opportunity to fast track our legalization narrative statement hearing. During the legalization narrative conference, the landlord's attorney made several promises to tenants regarding the plan for an all-electric conversion away from gas. They did not want to restore to gas, not because it was impossible, but because it would cost too much. They said they would comp the tenants electricity if we agreed not to pursue gas restoration. Based on this information, many tenants did not pursue restoration of gas, even though it was within their right. Then the landlords turned around and reneged on their promise. Not only that, the owners failed to pay the electricity on the building for several months, then sold the building. This left several tenants like me with electric bills over $10,000, which was the landlords that we were forced to accept when Con Edison shut off service to our building. We had to accept this debt, otherwise Con Ed would not restore service to the building. If I could please finish, thank you. I will never forget this time because it was when me and my whole family had COVID. Not only that, we were suffering from this grave illness, we were also without electricity, heat, hot water for over 5 days. My children were scared and depressed. I was deeply saddened and felt abandoned by the Loft Board. The Loft Board and the landlords who were in a position to help failed us. So much for being in this together. Their behavior was callous and uncaring, and I must admit I lost faith in the Loft Board's ability to protect tenants. The point I would like to emphasize is that had our critical narrative statement conference been recorded, we would have had the evidence and support our claim with the utility company and the court. And unlike the landlord's and it would be unlikely that the landlord's attorney would have made promises he knew if he was going on record. So please consider revising the language around the narrative statement. This is found on page 53, section E, to allow for the recording of this critical part in the legalization process. At least the parties would be provide a way for the parties to decide for themselves if they want to be recorded or not. The way it reads now, it prohibits all electronic recording. And another solution.
I think being able to record the narrative statement is probably a good idea. I mean, I'm sure you have to ask everybody, but I'm a tenant at 475 Kent Avenue. My name is Rob Swainston, and when we did our narrative, there was also, I don't know, to support the fellow tenant, there was a number of claims that the landlord had made that they were going to do that never materialized because we weren't able to record or to keep track of them. I'm going to speak in general. It's probably, I got a timer on so you can remind me. It's probably a good thing I didn't remember to bring my glasses because I can't read this to you because I can't even see it. I moved to New York in the late 90s, and in 1998 I took a loft at 475 Kent Avenue. Having a loft gave me an opportunity to establish myself as an artist in this town and to start what is now called entrepreneur business. And presently I'm an associate professor at Purchase College at State University of New York. And having a loft gives me an opportunity, affordable loft, to deal with the State University pay scales, which are really low. So maybe you guys appreciate that. Just putting it out there. Our building, lots of people in our building were very active in the extension of the loft law when it happened. And I have some fellow tenants here with me. Our building, I think you guys probably know a lot of the history of it, was sold from an original owner to a group of developers who had since in the beginning was really trying to use the loft law to weaponize the loft law to move out a number of tenants and to try to bring the building into luxury condos. They succeeded in removing roughly half, maybe a little bit more, the tenants, and the slow pace of construction has either been, I mean, I appreciate that it's very complicated to do this sort of work, but it's often just default harassment. I hope that I actually have 4 jobs. I'm a professor, I'm an artist, and I teach classes. And the 4th job is paying attention to the loft law. The owners have the ability to have counsel and lawyers and everything. We, the tenants, do not have this luxury. So I just hope that the rules that are being changed help tenants to make it simpler for them. I will also ask the loft law board to keep whatever mechanism we can to keep the landlords on track to finish their legalization. We want the building to be done. We want the construction to be done. And we want to not have the daily barrage of hammer drill and electrical outlets and water outlets. It just keeps going on and on and on. And I could give horror stories, and I have lots of friends here who have also done the same. But at 2 minutes and 52 seconds, I will let it go. Thank you very much for listening to me.
Give us 1 second. Mr. Delaney's gonna say something.
Yeah, I would just ask everybody who's offered testimony to also submit it in writing. You have until the 15th. That will give you a chance to perhaps expand on what you were able to comment within the 3 minutes. Some of the bedroom issues, perhaps you can explain a little bit more why you have to go from 2 bedrooms to 0, that kind of thing. It would be very helpful. Thank you.
One thing I'd like to add, if you want to share if you're a loft tenant, let us know what building you're in. If you want to share it, it would be helpful for us. Thank you.
I'm going to say everybody did not mention their name. I don't know whether it's terribly important. Can you hear me? But I would like to know your names, and I haven't been able to write them all down. Sometimes you speak so quickly, I can't try to write them down. So when you submit your stuff, your written stuff to the Loft Board, would you please then state your name and your address, of course, clearly. Thank you.
Hello, my name is Petra Hansen, and I am a resident at 46 Old Fulton Street in Dumbo, Brooklyn. First, I'd like to thank you all for being here and listening to this testimony to all of our grievances. I have been a tenant in that building since 2003. It was a 2-bedroom when I first moved in. It's my primary residence. I am a musician and designer, and it has enabled me to live as an artist in Brooklyn for that long. I have watched Dumbo change and become a very fancy neighborhood, and that has created a lot of opportunity for landlords. So my building underwent the legalization process on April 2019. After a couple of months, we had already endured, everyone in the building, a ton of toxic dust, and there was just a lot of mismanagement of the early stages of the legalization process of the renovations. In April of 2019, I was asked by my landlord to leave for a period of 10 days. I have this in writing. And my roommate and I at the time cooperated because we figured that he needed to do, a tremendous amount of work. It was going to be very messy and cause a lot of damages, and we didn't want to be there for it. So we cooperated, packed all our stuff out in a very short period of time, moved it into storage, which we paid for. We were not provided with alternative location during the 10-day period. After the 10-day period, we came back to our unit to find the place completely destroyed. There was no more plumbing. The sinks were in the tubs. Nothing worked. There was live wires, electric wires hanging from every wall, and walls had come down, and there was dust everywhere. So,
60 seconds.
Okay. The 10 days turned into 3 years. It turned into 3 years, which my roommate and I were both made homeless during a pandemic. I lived out of suitcases. It was a tremendously traumatic experience and caused incredible impact to myself and my livelihood. I was harassed. I was told to deal with it. I did eventually hire a lawyer. And so I have been
30 seconds.
Okay, I will just wrap it up. My stuff has been completely ruined. I have upwards of $20,000 in legal fees. My experience speaks to the loft lord's ability or lack of ability to enforce basic habitable conditions, or also prevent the legalization process from being an excuse for harassment. Thank you.
Hi, my name is Dave Morrissey Jr. I'm a tenant at 338 Moffett Street. I'm grateful for the loft law. I'm especially grateful for Inspector Lewis. I wish more people who were eligible knew their rights. Something on using the term contention as a point to make this process simpler. It's an irrelevant point because contention is already there before loft law comes in. Contention comes from owners lying about the building, putting tenants in danger, and harassment that happens leading up to our protection. My landlord sexually harassed people I live with and live nearby. He personally threatened me. He put us in danger by having multiple leaks and holes in our gas lines for years. He put us in danger by having to use the amount of space heaters that we had to use, because while our gas was turned off, our building ran solely on electric space heaters, which flipped our building-wide fuse multiple times. We had to go weekends from Friday to Monday mornings multiple times without any electricity or only half electricity. Our outlets have caught fire at times, all because they weren't forced to provide a substitute and consider the electric a pre-existing condition that they wouldn't have to remedy. When our gas was turned off, they came around the very next day asking us to sign a paper that would waive our rights, saying it was just so that they could make repairs. Obviously, this was a lie, and this predatory contract, which unfortunately I know a couple of these buildings have had to sign because they didn't know that they would come around. These contracts should not be allowed. It's absurd. So again, loft law is not causing contention. It's a lack of ethics. We've had our mail thrown out by our landlords. We've had the super scream at us and threaten people through our hallways. And aside from the harassments, they've made necessary ventilation upgrades in the lowest quality possible, resulting in many leaks. They refuse to examine security footage on our behalf to find out who was responsible for break-in and crimes. They refuse to provide heat in the hallways. They still refuse to add outlets and electric lines dedicated for weather control, so air conditioners won't have dedicated electric lines. They refuse to increase our electricity to 60 from 45, because apparently there's a policy, again, that allows electricity to be listed as a pre-existing condition. Somehow they got approval for this, and this is absurd when it's combined with having to use the space heaters, because it creates an incredibly dangerous experience. There are no requirements for ceiling insulation, so cold is cold and the hot is hot. Also, our ceiling, a lot of tenants worry about ceilings crumbling after a long time with not having proper repairs. I don't believe that there's a loft law policy in place for that. There might be. Although there are heat requirements, cooling requirements should be added as well. Lofts have too much heat in the summer and can be extremely detrimental to people's health as temperature rises. Sometimes bedrooms get over 100 degrees, even with proper ventilation. Sometimes for people who throw events, this can be even more detrimental. Cooling requirements in loft is incredibly important because it's different than the needs of an average apartment in New York City. Stronger enforcement, please. It's been said a billion times. There needs to be more notifications for tenants aside from just mail, for narrative statements or for meetings with the IMD. There should be emails as well. This is 2023. Tell tenants about narrative statements through email as well. Thank you, Loft Law, for having our backs. You help artists more than anybody. Thank you so much.
Hello, my name is Eric Baum. I am a loft occupant, and my partner who spoke before, she owns a loft building that we live in. I'm a builder, architectural designer, have been in the trade since I was a child, helping my father on the weekends. I've been around over 100 construction sites. The idea that every building situation can be summed into the same time requirements, the so-called time compliance timetable to finish and get a CO, is a political fantasy to begin with. Most empty buildings would maybe make it across the line in that time. Forget about occupied buildings and seriously forget about small buildings with limited resources. Further add to that the limited number of accredited professionals who are steeped in the complexities of loft law. The balance of the equities relative to the compliance time schedule and the difficulties again of getting even possible extensions is completely out of balance. Add to that the time the loft board has taken to process applications, ours in particular over 36 months, and has clearly created a toxic political atmosphere where a great number of tenants, encouraged by their attorneys and most not of great financial need, are not paying the rent because the owner got out of time compliance, which is not at all flexible. Once you get out of one level, you're never going to get back in. So you can forget about the rent. You can forget about paying a lot of attention to your tenants because they're not going to pay for it. You're not going to really have a lot. You know, that's why this situation is happening. Owners are losing a lot of money. Tenants are pocketing it. My tenant hasn't paid 90 months of rent approximately. They've bought a second home on the with the money. They were awarded a 5,000 square foot apartment. We could build 5 affordable houses in that space. The policy needs to be addressed and that a balance of the equities will allow such compliance to fully allow the collection of rent throughout the remainder of the process. This could be accomplished partly by having the narrative statement waived for doing the public areas of the building first expeditiously and reaching 7B compliance in that area. And that would give owners the right to collect rent throughout the process. And the long time that everyone's asking for more time in narrative statements and stuff could be solved in that way. So to finish and to get a C of O in 36 months is a tall order today. A projection that was created in 1982. It's not particularly doable in every single building.
That's your time. Thank you.
The tenants probably across the city have held hundreds of millions of dollars in their pockets. So it's not really helping to in unpaid rent. And that money is not being taxed. Why is it going to tenants necessarily? It should be going perhaps to the loft board and then redistributed to a diligent owner. A tenant, well, I'll just end it there, okay? I think there's just a lot of problems that need to be addressed. And I would end by saying that we have had a permit to do work in our building for 10 years and have diligently kept the building in great shape. And I've never had the kinds of complaints that so many people are talking about here waged against us. Thank you.
Hi, my name is Arthur Purvis. I'm also a tenant along with Aaron Scaturo, who spoke earlier at 79 Lorimer Street. The gentleman before me said that the landlords only have 36 months for compliance. That is patently false. They're allowed to apply for numerous extensions. That you're not speaking. Anyways, I would also like to talk about Jason Frosch, the lawyer who spoke earlier, talking about responsible parties. The responsible parties he represents are the same responsible parties that locked me and Aaron out of our home for 4 years. When I returned to my home, my apartment had been infested with pigeons and everything was covered in pigeon feces. I have Jason Frosch fought tooth and nail for all 4 years. He is still fighting tooth and nail. We are 8 years in. No restitution has been offered. There have been numerous court orders for providing Mr. Scaturo with heat or a shower or cleaning the rest of the pigeon feces out of my unit, which has still not been done. 4 years later, multiple judges have been to my building. Multiple lawyers have been to my building. The point I need to make is, there needs to be, as everyone has said, the key is enforcement, right? If there's no enforcement of the rules, then, my landlord, if there's no enforcement of the rules don't mean anything. My landlord is currently carrying $150,000 worth of fines, about 40 violations on the building from the DOB. They had another building where they were counting $750,000 of fines. To give you some idea of who we're dealing with, I think they had like 150 violations. That's not a loft building, but it gives you, they without more enforcement, more consequences, these people don't really see any need. This is just the cost of doing business. Fines in the city is, I think, 9%. If you look at the New York Times article a couple of years ago, there were a bunch of bricks falling on people and killing them in Midtown, and New York Times investigation, it's like 9 to 12% of fines get collected. So slapping a several $1,000 fine or $100 fine on a landlord who isn't going to pay it and sees no need to pay it and collects, there's no interest, there's no whatever, and the fines disappear when they sell the building is, I don't know what the right answer is as enforcement goes, but that is, it's clearly not working, right? Anyways, I don't even know what else to say. My horror story is very similar to Aaron's and everyone else's. I think the key is enforcement. I'm very grateful for Inspector Lewis, who has been helpful throughout this process. But other than that, I think we have a long ways to go. Thank you very much.
Thank you, everyone, for coming here today and for testifying. As I mentioned earlier, we're going to keep the comment period open for another week. So if you're here and you'd like to submit written testimony, you can do that for the next week. So feel free to, add additional details to what you said here today. And for the folks that are watching online, you can also submit written testimony for the next week. So that'll conclude our December 8th, 2022 public hearing. Our next public meeting will be.
Can you just expand on the process with the next? So the public submits comments, and then what happens?
At the January meeting, the staff will present to the board a summary, all of the comments and the summary of the comments. So you'll be able to see it. Okay, any other?
Integrated, or is there another round of updates, potential updates to the rules based upon public input?
In January, the board will have an opportunity to discuss the comments and make any changes if it sees fit. Okay.
Will we meet in private after the open meeting here today or not?
No.
Okay.
I would just, is it, if the board staff does not recommend changes to the draft as it's currently written, would we be voting to adopt the rules in January?
If the board does not have any changes it wants to make to the proposal that's before you, it's possible that we can vote it completely out, yes.
Okay, because many of you have probably not been following the situation that closely, but the first draft of these rules was discussed by the board when Barack Obama was president. So it's been a long time.
Somebody wants to know if comments can be submitted anonymously.
Yes, you could just put someone else's name online, or John Doe or anonymous on the website in the comment period. Okay, I mean it has a line for your name, but certainly you could put something else there. Okay, anything else?
All right, thank you. So that'll conclude our December 8, 2022 public hearing. Our next public meeting will be on January 19, 2023, here at 22 Reed Street at 2 p.m. Thank you, everyone.